Thank you, Madam Speaker. For the average citizen in the digital age, we have entered uncertain times. To almost everyone at face value, the convenience of our time is remarkable. Access to any piece of information is available at our fingertips. Any item imaginable can seamlessly be ordered and delivered to our door. Many government services can be processed online instead of in person. Canadians have taken these conveniences for granted for many years now. The pandemic accelerated our ascent or descent, depending on who you ask, into the digital age. The inability to leave our homes and the necessity to maintain some rhythm of everyday life played a significant part in that. But around the world, we saw governments taking advantage of the plight of their citizens. Public health was used as a catalyst for implementing methods of tracking and control. Social media, which has been putting a friendly face on exploiting our likes and dislikes and movements for years, continues to develop and implement that technology with little input or say from their millions of users. Canadians no longer can be sure that their personal information won't be outed or doxed to the public if doing so would achieve some certain political objective. We saw that unfold earlier this year with the users of the Give, Send, Go platform. The long-term ramifications of our relationship with the digital economy is something that Canadians are beginning to understand. They're now alert to the fact that organizations, companies, government departments operating in Canada today do not face notable consequences for breaking our privacy laws. As lawmakers, it's our responsibility to ensure that Canadians' privacy is protected and that that protection continues to evolve as threats to our information and anonymity as consumers unrelentingly expands both within and beyond our borders. That brings me to the bill we're discussing today, C-27. It's another attempt to introduce a digital charter after the previous iteration of the bill, C-11, died on the order paper in the last Parliament. My colleagues and I believe that striking the right balance is at the core of the debate on this bill. On the one hand, it seeks to update privacy laws and regulations that have not been modernized since the year 2000, implemented in 2005. It would be hard to describe the scale of expansion in the digital world over the last 22-year period in a mere 20-minute speech. It's therefore appropriate that a bill in this form, any form, particularly one as long awaited as C-27, is considered by Parliament to fill the privacy gaps we see in Canada's modern-day digital economy. Parliament must also balance the need for modernization of privacy protection with the imperative that our small and medium-sized businesses remain competitive. Many of these businesses sustain themselves through the hard work of 2 or 3 employees, or perhaps even just a sole proprietor. We must be sensitive to their concerns as Canada improves its image as a friendly destination for technology, data, and innovation. This is especially true as our economic growth continues to recover from the damaging impact of the pandemic lockdowns, crippling taxes that continue to rise, and ever-increasing red tape. That extra layer of red tape may very well be the catalyst for many small businesses to close their operations. No one in this House would like to see a further consolidation of Canadians' purchasing power in big players like Amazon and Walmart, which have the infrastructure already in place for these new privacy requirements. In a digital age, Canadians expect businesses to operate online and invest a certain amount of trust in the receiving end of a transaction to protect their personal information. They expect that it will be used only in ways that are necessary for a transaction to be completed, and nothing more. In exchange for convenience and expediency, consumers have been willing to compromise their anonymity to a degree. But they expect their government and businesses to match this free flow of information with appropriate safeguards. This is why C-27 and any other bill similar to it must be carefully scrutinized. As many of my colleagues have already indicated, this is a large and complex bill, and we believe that its individual components are too important for them to be considered as one part of an omnibus bill. There's 3 separate pieces of legislation to this bill. Part 1, the Consumer Privacy Protection Act would repeal and replace decades-old measures concerning personal information protection. Part 2, the Personal Information and Data Protection Tribunal Act would strike a tribunal to administer penalties for violation of the CPPA. Part 3, the Artificial Intelligence and Data Act, is brand new to the bill and sets up a framework for design and use of AI in Canada, which is almost entirely unregulated. Long before the widespread use of the Internet, our Supreme Court was clear that privacy is at the heart of liberty in a modern state. The government should be taking every opportunity possible to enshrine privacy in our laws as essential to the exercise of our rights and freedoms in Canada. As Daniel Theron stated in the Toronto Star earlier this month, democracies must adopt robust solutions anchored in values, not laws that pretend to protect citizens but preserve the conditions that created the digital Wild West. The value of privacy should anchor this bill. Instead, this bill fails right out of the gate. The preamble states that the protection of the privacy interests of individuals with respect to their personal information is essential to individual autonomy and dignity and to the full enjoyment of fundamental rights and freedoms in Canada. By placing this value in the preamble of the bill where it has no teeth raises distrust rather than confidence that this government truly respects Canadians' privacy rights. The CPPA would require organizations, companies, or government departments affected by the bill to develop their own codes of practice for the protection of personal information. While these codes must be approved and certified by the Privacy Commissioner, one can only imagine the variation of protection that will result. This requirement adds significant red tape, yet another onerous task to the backs of small and medium-sized businesses that employ most Canadians. It also creates more work for the Privacy Commissioner to parse through complicated codes created by larger, wealthier, powerful corporations, companies, or government departments that have legal teams whose sole purpose is to find creative ways to perhaps game the system. Although it would take more time and investment up front, the better option in my mind would be to create a standard code of practice which all entities are to follow. This could certainly be taken on as one of the first responsibilities of the expanded Office of the Privacy Commissioner in defining the universal code of practices, where confidence in the process would be greatest and where the greatest level of concern for individual privacy actually exists. This bill states that personal information can be transferred without Canadians' consent for purposes ranging from research to analysis to business purposes, but it must be de-identified before this can take place. At first glance, this is a positive measure until it's compared with anonymization as an alternative. According to the bill, de-identification means, and I quote, to modify personal information so that an individual cannot be directly identified from it, though a risk of the individual being identified remains, end quote. That leaves much to be desired when compared to the anonymization of personal information. The bill defines that as, and I quote, means to irreversibly and permanently modify personal information in accordance with general accepted best practices to ensure that no individual can be identified from the information, whether directly or indirectly, by any means, end quote. Any attempt to identify individuals from de-identification information is prohibited, except for approved circumstances. While many of these approved circumstances relate to the ability of an entity to test the effectiveness of its de-identification system, the potential for abuse still exists. This bill would be improved by eliminating those chances for abuse. We should examine replacing de-identification with anonymization wherever possible. Comparing C7 to the EU regulations, there are several ways in which the CPPA does not live up to what is widely considered to be the international golden standard of privacy protection, and that's in the European Union 2016 General Data Protection Regulation, or GDPR. A glaring example of C27's inferior protections, the GDPR processes personal data in such a manner that it can no longer be attributed to a specific individual without the use of additional information kept separately, subject to technical and organizational measures. This is a security and privacy by design measure of the GDPR. Regarding what C27 considers to be sensitive information, there's nothing to indicate what sensitive information actually entails. It is also limited in its application. Only the personal information of minors is considered to be sensitive. All information Canadians surrender to any entity should be considered sensitive. On the other hand, the GDPR possesses a particular regime for special categories of personal data, including racial or ethnic origin, political opinions, religion or philosophical beliefs, trade union memberships, genetic data, biometric data, data concerning health, sex life, or sexual orientation. We're happy to see the consent is better defined in C27. However, exceptions for activities not requiring consent remain in place. They are so broad, some of them, that an entity could interpret them as never requiring consent. These are loopholes that Canadians should not have to endure when they're required to check the box that they have read and accepted the terms before they're able to interact with a digital site. For example, legitimate interests in a given situation may be used by companies to disregard consent. there's a danger that these interests will outweigh potential adverse effects on the individual. Attempting to define legitimate interests allows too much for interpretation, and interpretation is not something that lends itself to privacy laws. The use of personal information could also be exempt from consent if a reasonable person would expect the use of their information for business activities. There's no definition as to what a reasonable person is. The bottom line is that there are far too many loopholes in vague terms. For the savvy, wealthy, or well-lawyered, the potential for abuse exists. The GDPR, conversely, is unequivocal on consent. It must be freely given, specific, informed, and unambiguous in an intelligible and accessible form, and is only valid for specific purposes. Canada should have followed that example. Canadians cannot help but wonder why C-27 doesn't. Under the proposed CPPA, there is no minimum age for minor consent, nor is minor defined. In the EU, the GDPR sets out a minimum age for minors' consent at 16 years of age. Member states also have the flexibility to allow for a lower age, provided the age is not below 13 years. If a breach of personal information does take place, C-27 will make Canada slower to respond than its international counterparts. This bill mandates that a notification be made to the Privacy Commissioner of any breach that creates a real risk of significant harm as soon as it's feasible. The individual affected would also need to be informed, but again, as soon as feasible. The GDPR sets out a mandatory notification must be made to the supervisory authority without undue delay, or 72 hours after having become aware of the incident in certain circumstances. Prior to and even after the introduction of this bill, Canada is lagging behind internationally. The GDPR is already 6 years old. That's 6 years of extra time in which the Liberals have failed to develop this legislation to meet the robust international standard. In C-27, the Privacy Commissioner is empowered to investigate any certified organization for contravening the Act. The Commissioner has been rightly asking for increased power and responsibilities for some time, and this goes beyond a mere recommendation to violators to stop their actions. The Commissioner can now recommend greater penalties of no more than $20 million or 4% gross global revenue for a summary offense, and no more than $25 million or 5% gross global revenue for an indictable offense. These penalties should add more bite to what the Privacy Commissioner can do and impact how Canadians' personal information will ultimately be treated. The penalties will also apply to a greater number of provisions, such as actions that contravene the establishment and implementation of a privacy management program, and failure to ensure equivalent protections for personal information transferred to a service provider. However, these new powers for the Privacy Commissioner hit a dead end when taken in context with the second part of this bill, which establishes a tribunal. The Personal Information and Data Protection Tribunal will consist of no more than 6 members, and only half of what those members are must have experience in information and privacy law. The Privacy Commissioner would have order-making authority and the ability to make recommendations to this tribunal regarding penalties. However, the tribunal has the power to apply its own decision instead, which would be final and binding. Except for judicial review under the Federal Courts Act, the tribunal's decisions are not subject to appeal or to review by any court. These are power equivalent to a superior court of record. The existence of this tribunal dulls the new teeth given to the Privacy Commissioner. While the Commissioner can recommend that a penalty be levied for violations of the CPPA, it is the tribunal that has the power to set the amount owed by these organizations. The cost associated with striking this tribunal is also a concern. Despite the fact that its work will likely be limited to a handful of times per year to determine penalties, it will apparently require a full-time and permanent staff of 20. I'm deeply concerned that this government also has a bad habit of striking advisory councils or so-called arm's-length regulatory bodies in advance of bills being debated and passed in this House, long before the ink on legislation is even dry. My memory is drawn to when in the past a bill, as it was being debated in the House, was there I inquired about the details of the proposed Environmental Council and was told with great zeal that it had already been established and the members had been appointed before the bill even was debated in this House. Can the current Prime Minister opposite tell us if this tribunal will be struck only after Parliament has dealt fully with this bill? Will they be transparent with Canadians on how the appointment process will be undertaken? Can they assure Canadians that a full-time and permanent staff of 20 has not already been determined? After 7 years of Liberal power, the leverage of patronage in this place runs deep. Part 2, the Personal Information and Data Protection Tribunal Act should be removed, as it is a bureaucratic middleman with power that will conflict and create redundancy with the Privacy Commissioner's new powers. New powers that mean little if they are not coupled with quick and effective consequences for violators. It will prolong decisions on fines and harm Canada's reputation on holding violators accountable. It would also not align with our friends in the EU, the UK, New Zealand, and Australia, who do not use a tribunal system for issuing fines. It just goes to show Canadians that when it comes to making big government needlessly bigger, Liberals do it well. The third and final part of this bill is the only entirely new component. The Artificial Intelligence and Data Act seeks to regulate an entity, artificial intelligence, that has not been regulated before in this country. It would set standards for the creation and use of AI systems in Canada by both domestic and international entities. More specifically, international and interprovincial trade and commerce in artificial intelligence systems would be regulated through common requirements for the design and use of those systems. It would prohibit certain conduct pertaining to AI systems that could lead to harmful results for individuals and their personal data. There's that mention of personal data. This is a massive undertaking attempting to regulate something that up to this point has been almost entirely unregulated. I also understand that consultations on this were only initiated in June. Logic would dictate that such a bill requires a careful scrutiny and time to get it right. Requiring record-keeping and human oversight are positive developments. What we find difficulty with is getting a clear picture of what the final framework will look like, as the minister alone is empowered to establish these regulations. The minister will be able to act independently from Parliament in making rulings and imposing fines. In an age of uncertainty and new horizons for our relationship with AI, this is unacceptable. Parliament, at the very least, independent experts and watchdogs should be central to the creation and enforcement of these rules. It appears that once again this government has chosen to simply tack on a crucial area of concern to Canadians to an already complicated bill and wishes to again entrust sweeping powers to a minister to act independent of parliamentary oversight. Well, Speaker, my final thoughts on today on C-27 are as follows. Conservatives are considering this bill through a reasoned approach, appreciating that stakeholders who have been calling for this legislation for years are watching today's debate closely. It's absolutely clear that modern-day protection for Canadians' personal information is required. They must have the ability to access and control its collection, use, monitoring, disclosure, and the right to delete or right to vanish. How can we ensure that data is protected through watertight regulations and strict fines for abuse, while also realizing that not every business affected by this bill will have the resources of Walmart or Amazon? Small and medium-sized businesses should be shielded from onerous regulation that stifles their growth. This is not to say that business interests should weigh equally with personal privacy, but there's a balance to be had, and I believe the Liberals do not have it right here. And furthermore, in a cynical attempt to move their legislation agenda forward, the Liberals have bundled changes to privacy laws with a first-of-its-kind framework for artificial intelligence that once again intends to govern through top-down regulation, not legislation. The Liberals should commit today to splitting this bill up to allow Canadians a clear view of its intended impact. With the commitment that we have, Conservatives will be looking to do the hard work in committee to improve the long-awaited but flawed elements of this legislation. And so, even in an age of convenience, the world in which we live grows even more complicated by the day. So, Canadians deserve privacy protection worthy of 2022 realities and beyond. Thank you.
Questions and comments. The Honourable Parliamentary Secretary to the Government House Leader.
Yes, thank you, Madam Speaker. This is, in fact, very progressive legislation that deals with an area of concern that Canadians have and something in which the government is very much concerned about. And that's why we have the legislation. Safety for privacy is of critical importance. We are, in fact, moving into such a significant digital economy, Madam Speaker. Databases, the issue is there. It's there. It's today. And I'm somewhat interested in knowing exactly where the Conservatives are going to fall on this legislation. When I hear the member, she seems to express concerns about the area, but there's no indication really in terms of, is the Conservative Party going to be supporting the legislation? We just heard from the Speaker that it's going to be, in terms of voting, on 3 parts. Does the member have any suggested amendments that she is thinking of offhand? I believe that Canadians need this legislation, and just to get her thoughts in regards to, wouldn't it be nice to have legislation of this nature at least pass out of second reading before the end of the year?
The Honourable Member for Yorkton Melville.
Thank you, Madam Speaker, and I thank the member for his question. I don't know if throughout my speech you heard my concerns around the fact that this falls so short to what our international colleagues have created, that is so much stronger in the European Union's 2016 General Data Protection Regulation, or GDPR. So obviously we have indicated on this side of the House that we have a lot of concerns, especially with the lack of definition of so many terms that are included in this legislation that need to be clarified. Otherwise, it's just going to create all kinds of additional problems when what we need more than anything is clarity for Canadians on their confidence that their privacy is being protected.
Questions and comments, the Honourable Member for Rivière-des-Mille-Îles. Thank you, Madam Speaker. I'd like to ask the following question to my colleague. I was fascinated by an aspect of the bill, which is the one on artificial intelligence. Personally, I found that in there was a general framework and a legal framework that was very interesting. There's a goal of regulating exchanges through Canada, interprovincial, and to ban certain practices. Does my colleague at least agree on that it's an important step forward in an area that's really developing artificial intelligence? Thank you.
Yorkton Melville.
Thank my colleague for the question, and I do agree that this is an area that Canada is way behind on, and it's absolutely crucial that we get started in creating that framework. However, what disturbs me is the fact that it was just tossed into this bill dealing with other issues that are significant in themselves, and this alone wasn't even started to be consulted on until June. So I think it is very rash of us to consider it in this legislation. I am thankful that it is going to be voted on separately.
Questions and comments, the Honourable Member for Nanaimo Ladysmith.
And thank you to the member. Following perhaps a little bit on the question that was just asked prior by my colleague, we saw just recently 19,000 Canadians were affected by the recent Equifax breach as one example, and that the Office of Privacy Commissioner concluded that the Equifax did not fulfill its obligations to Canadians and entered into a compliance agreement with no fines, no penalties, and compensation for Canadian victims. We're seeing very different fines and penalties for Canadians and Americans. And Canadians are getting the short end of the deal. And I'm wondering if the member could clarify if she feels that it's important that we bring parity and equivalency for citizens on both sides of the border.
Honourable Member for Yorkton Melville.
Yes, I thank the member for the question. There's definitely many areas where Canada is on the short end of the stick when it comes to many of these issues. I certainly think of our ability to have Wi-Fi in our cell phones at a reasonable price in comparison to other countries. In this case as well, again, I think it's really important that we do the due diligence needed, and certainly Canadians, we need to have the same level of ability to have our privacies protected that any other nation has. And I would encourage us to look at the EU version of this and do a far better job of incorporating a lot of what is needed to function even internationally with our other allies.
Good job.
The honourable member for Central Okanagan, Similkin and Nicola.
Thank you, Madam Speaker, and I want to thank my colleague for her speech. I too share concerns around C-27, particularly around the Artificial Intelligence Data Act. Specifically, I agree with her. Having one minister solely delegated the responsibility for a wide variety of different regulations that could happen that might affect both private as well as public is too much. And as Parliament, we should be looking into this and we should be setting out those parameters. Madam Speaker, the government has basically said to the private sector, we can hold you accountable for serious harm, something they don't even define in the law in C-27, while at the same time giving themselves the ultimate loophole. They say that they can exempt themselves. Not only that, Madam Speaker, some of them are trustworthy organizations that it says in there, but the minister literally can say that any provincial or federal commission or body that it feels should be exempted as well from being allowed to use artificial intelligence and held at a different standard in the private sector can be done. Does the member agree that this particular section, more than anything, needs to be looked at? Because I believe it is too much government overreach, and they've essentially given themselves the ultimate loophole.
Honourable member for Yorkton Melville.
Thank my colleague for that question, because that is my deepest concern as well. I mean, we've seen this government on other pieces of legislation come forward and give themselves the authority to create a situation where really it is out of the hands of Parliament and into the hands of a minister as to how things will develop or be implemented. Sorry. So I certainly agree with him that we need to do way more work and make sure that Canadians are truly protected, not by just one individual at a certain point in time who has a great deal of power. In some cases, in that situation, I would say too much power, and ensure that it is done properly with Canadians in mind.
Questions and comments. L'honorable député de Beauport-Limoilou.
The member for Beauport-Limoilou. Thank you, Madam Speaker. I understand that the Canadian financial sector is feeling stressed because of European rules and regulations, and we might lose access to the important European markets, but Quebec's rules and regulations already aligned with those of Europe's. Yet Bill C-27 has to be well crafted. So does my colleague fear that pressure from the financial institutions, the financial markets, that at committee their influence will be felt?
Thank you for that question, and that is a good one, because this is an example of circumstances where Canadians are having trouble trusting their government to do the right thing, to truly have their backs in this area. We've already seen circumstances in the past year or two where our banks have had unbelievable impact on Canadians' lives by having the powers entrusted to them to do things that are out of line, out of step with really truly protecting the privacy of Canadians.
Questions et commentaires. Questions and comments. The honourable member for Bay of Quinte.
Madam Speaker, and thank you to my colleague for her great speech. She talked about that tribunal aspect, and I think it's very important that in this bill, when it comes to privacy protection, besides the Privacy Commissioner, we're going to have another element of a tribunal. Most importantly, I think, out of that process, there will also be still the federal court. So when it comes to having a citizen who's had its data breached, and this is the whole premise of this bill, is to protect that of citizens, children, and adults alike, there's still going to be a tribunal added. So my questions to my colleague are, is there any other jurisdiction that's using a tribunal? And if they aren't, why do we think that's even included in this bill? Thank you, Madam Speaker.
Honourable member for Yorkton Melville.
Thank you very much. That's a great question. It is deeply disturbing to me when I look that the European Union, the UK, New Zealand and Australia, none of our allies have chosen to use a tribunal. The power is there for their commissioners to make sure that they are being the various entities are being held accountable in regard to individual privacy. Their rules are far, far more specific than ours are in this bill thus far, and it just shows that we are weaker in truly protecting Canadians' privacy rights in comparison to our allies, and it is a sign that we are doing things with an ulterior motive that disturbs me, because it gives power again to a different organization within the system that they're creating to basically give different organizations, perhaps government departments, an out.